Originalism has become sort of a buzzword in the news and among legal scholars, especially for those focused on the Supreme Court. Some think of it as a politically conservative approach to constitutional analysis, while others say it's not political at all, and that anyone on the ideological spectrum can be an originalist. As someone getting ready to graduate and build a career that I hope will include appellate advocacy, I'm looking to understand more about how this concept evolved and how it's being applied today. In that spirit, I'd like to welcome you to Discourse, Georgetown Law's new conversation platform bringing together experts, faculty, and students to facilitate discussions about the latest in the law. To discuss the topic of originalism, I was fortunate to have the chance to talk to two of our leading experts on constitutional analysis here on campus. One happens to be our dean, William Treanor, who has a PhD in constitutional history as well as his law degree, and also Alexa Gervasi, a Georgetown Law graduate who came back to serve as executive director at the Georgetown Center for the Constitution. I hope you enjoy the discourse. Welcome, I'm Ciara Cooney. I'm a third-year law student here at the Georgetown Law Center. I'm joined today by Georgetown Law Dean William Treanor and the Executive Director of the Center for the Constitution here at Georgetown Law, Alexa Gervasi. We're here to discuss originalism and particularly the emerging use of originalism by liberal scholars and jurists and advocates. To just get us started, I would love to hear from both of you how you would define originalism, and Alexa, we'll start with you.
Yeah, so I define originalism as a commitment to the original public meaning of the text of the Constitution.
And Dean Treanor?
I would give it the same definition. It's an attempt to recover what the Constitution originally meant, focusing on its words and how they were understood, and applying that as a jurisprudential philosophy.
And so in that vein, the commitment to the original public meaning and identifying the meaning of the text, what is kind of the mythological approach that you think should be followed in doing that?
Yeah, so I think originalism, public meaning originalism, by some scholars, because of course there are different veins and approaches to originalism, is to really divide it into two steps. One is, what do these words mean? So how do we interpret the words? And that's just a semantic question. There is an answer. These words have a meaning, and we look at what did the general educated public, what would they have understood those words to mean at the time the provision was enacted. And then we say, well, how do we apply that to the law? How do we construct the application of this meaning to the law? And of course, there are times where the text runs out, right? So we know 35 years old to be president. That's pretty clear. The text is easy to understand. But when we get into something like what does reasonable mean in the context of the Fourth Amendment, there in that area we have to do a little bit more work, and we have to construct the meaning of the word reasonable, and we would look to history and text and how was the Fourth Amendment applied around the time at common law, and what was the purpose, what was the function of that specific text? What was it trying to achieve, and staying faithful to the purpose of the text. And that's what we do when the text itself doesn't give us the full picture, the total answer.
So I think it's important to recognize that there are different approaches to originalism.
Mm-hmm.
So your question was absolutely right to start us off with. So when originalism first started to become powerful in terms of modern jurisprudence shaping the court, there was a focus on drafter's intent. Mm-hmm. So what did the Constitution mean in the Philadelphia Convention to the people who wrote it? Mm-hmm. So that was really phase one. Then phase two focused on what we call framers' intent. Mm-hmm. So after the Constitution is proposed, it goes to 13 state ratifying conventions. Mm-hmm. And sometimes what they said in the state ratifying conventions gave the words a different meaning than the people in Philadelphia gave it. So the ratifier's intent is you look at what the ratifiers talked about as what it means. The dominant approach right now is to look at the words themselves. What do the words themselves mean? So there are two things that I would highlight. One is, as I look at it, we really focus in on the words. And then the other aspect, which I think may be kind of a difference between us, is I also think about what was the role of courts. So it was not just what did the words mean to an educated person, but how would courts construe those words? Because judicial review was actually well established at the time of the founding, which people don't recognize, but there was a construct on how courts viewed the Constitution. So for me, that's also part of originalism.
Okay. Very, very helpful to understand. And as a framing, and I appreciate you discussing kind of the phases that originalism and the conception of it has gone through. And that's one of the things that I wanted to discuss a little bit more. Originalism is often thought of as a conservative legal theory. And thinking about the methods that you have both outlined, do you think that it is inherently a conservative legal theory, or is it only considered that way because it has been most often associated with conservative legal jurists like Justice Scalia, for example?
So I have to say, this is very interesting to me. When I started law school in 1980, and actually in 1980, originalism was a liberal theory. So the Supreme Court justice who was the originalist was Hugo Black. And he was the one who essentially said the Bill of Rights and its provisions apply to the states because of the text of the 14th Amendment. So that was novel. He was the first one who pushed that. He was one of the more liberal members of the court, and he was really the only originalist. And then in terms of scholars, probably the leading originalist scholar, or really textualist scholar, but I would say originalist scholar, again, when I started law school, was a University of Chicago professor named William Krosky. And he wrote a couple of books called Commentaries on the Constitution, which were really deep dives into original meaning. And he had a very expansive conception of how to read the Constitution, and really very liberal. So, if you go back to 1980, originalism and liberalism were thought to be in sync. So it's really only since then. And Justice Scalia and Attorney General Meese were really kind of the two people who, in the most dramatic ways, changed it. Judge Bork was also kind of an early person pushing for a conservative originalism. And that's come to dominate both the court and academics. So now, when I talk to people and I say originalism used to be thought of as a liberal jurisprudence, they're like, that can't be right. But that's a historical artifact. It has not always been that way.
Yeah, and I think, if we think, what's interesting about the year 1980 is that's really when the term originalism actually started being used. Before that's not really the language that was used, but the idea of originalism itself, and textualism goes all the way back to the Constitution, right? It's in Marbury versus Madison. Thomas Cooley, in his treatise about constitutional interpretation, was promulgating the same ideas about how to approach the law in the Constitution's text that public meaning originalists put forward today. We just didn't think of it in the same theoretical terms that we discuss it now. And I think that that's absolutely right, that in the 1980s and into the early 1990s, Justice Scalia and Attorney General Meese began developing public meaning originalism, or what are we going to look to find the original meaning contra ratifier's intent or framer's intent. Like, let's look at what did the public understand these words to mean? And that starts to happen in the 80s and 90s. And I think to your question of, is that why it's thought of to be conservative? I think that's probably right, that Justice Scalia was the one, was the big brain kind of behind putting forward this idea. But he certainly wasn't alone. I mean, today, one of the biggest scholars in originalist theory is Larry Solom, who would not identify as a conservative.
So Ms. Gervasi's point is right, that originalism goes back to the founding. Mm-hmm. So actually the very first case in which the Supreme Court considered whether they could invalidate a congressional statute involved direct taxes, mm-hmm. and what those words meant in the Constitution. And it's a great example of sometimes the ambiguity of text in the Constitution. So they have a big debate at the Constitutional Convention about what kind of taxing power should the federal government have, and they go back and forth and big heated argument, and then somebody says, well, we'll make the term direct taxes. Everybody's like, fine. We don't want to fight about this anymore. And then somebody says, so what is a direct tax? And Madison's notes say, no one responded. So the very first judicial review case, the carriage tax case, they're fighting about what the original meaning of this phrase was. And again, the problem that you sometimes see is the meaning runs out, and they're fighting about the text. And actually, one of the justices, Justice Patterson, says, now when I was in the Constitutional Convention, this is what I thought it meant. So sometimes we say, oh, they never looked at drafters' intent. Well, that's an example of the very first case. Mm-hmm. They looked at drafters' intent. But, I think I always think that there were a couple of things. So I think for Justice Scalia and Judge Bork and Attorney General Meese, in the 1980s, they were confronted with a Supreme Court that was really dominated by a progressive jurisprudence. Mm-hmm. The Warren Court, and then in a lot of ways the Burger Court, really continued on in the footsteps of the Warren Court. And they were looking for an alternate constitutional jurisprudence and embraced originalism because, first of all, it was a way to criticize progressive originalism, and because it provided kind of something that you could anchor. Mm-hmm. And so it was not, the judges were not kind of what seemed right to them. And I think for Justice Scalia and Judge Bork and Attorney General Meese, recapturing originalism was also consistent with conservative jurisprudence. Mm-hmm. So that's something that we'll get to later, and that I disagree with.
Mm-hmm. Okay. So what I'm hearing is within originalism, there's a commitment to the text and to the words and to identifying those meanings. And as we have seen, and as you've both talked about, the different figureheads that have sponsored that in the conservative or in the liberal wings, I'd love to hear just a little bit more about how you really see the conservative approach or the progressive and liberal approach to originalism differing, and how they share the same approaches and what the distinctions are between them.
Yeah, so I actually reject the idea of a conservative approach to originalism versus a liberal approach to originalism, because to my mind, or the reason I'm an originalist, perhaps we should start there, is because it is supposed to be objective. It is supposed to respect the rule of law, and it is supposed to give some legitimacy to the process. There is something concrete we are looking to that is not results oriented. Mm-hmm. And so I think as properly viewed and applied, originalism should not be conservative, nor should it be liberal. It should just be. And sometimes that means you get to an answer you don't like. And what that means is that you have to amend the Constitution if that's where you get to. That's what originalism tells you you must do. So I think the way they differ is in the results that either side wants. to apply originalism properly requires good faith and a good faith effort to reach the answer, whatever that might be. I think what we see happen is cherry picking. So cherry picking the dictionary that I want to choose to understand the meaning of this word, cherry picking the text that, or excuse me, the historical examples that serve my results, and perhaps not giving the full story about the other side or giving the full picture. And so I think that that's where we get into trouble with liberal versus conservative originalism, is starting from the place of what answer do I want and how can I work backwards through history and text to get there.
So, I mean, I think Ms. Gervasi is right, and I would agree. You know, any consistent jurisprudence has to lead to some results you're unhappy with, right? The president of Princeton, Chris Eisgruber, has a phrase which I've always liked, which is "no pain, no claim," right? You know, if you the result is always one you're happy with, then it's really not a coherent jurisprudence. You've just come up with some way to, you know, a constitutional jurisprudence that's really just your point of view, right? So, I mean, I would say, so let's talk concretely about the way in which the Constitution gets drafted. So, so kind of the norm right now is James Madison's the father of the Constitution. Justice Gorsuch says it's all about Madison. And to some extent what we see now is that both the left and the right, as they do original meaning, struggle. They all assume that Madison is the father of the Constitution, and then they struggle with what Madison wanted. So the Federalist Society, if I were wearing a Federalist Society tie, it would have little heads of James Madison on it. But 20 years ago, when Georgetown started a progressive constitutional law group for students, now it's the American Constitution Society. It was originally the Madison Society, right? So everybody kind of fights over Madison. You know, what I think, and this is really my thought, so I'm kind of a school of thought of one, is that, you know, if you look at the Constitutional Convention, there are two people who actually draft most of the Constitution. One is James Wilson, and the other is Gouverneur Morris. And so they're really the drafters of the Constitution. And so the text is largely theirs. So we have a tendency to look through it as what would Madison have wanted, when in fact it's really what Wilson and Morris wanted, because they actually wrote the text. And their jurisprudence doesn't align with either liberals or conservatives today. So just in terms of kind of big thought, they're both very strong national power advocates, unlike Madison. Madison's a nationalist, but his real concern is that the federal government be strong enough to keep the states in line, right? He's got a kind of a negative vision of national power. You know, Morris and Wilson, they want the national government to have, you know, almost plenary authority. And then they wrote the Constitution. So for liberals, you know, they love that, right? So, I mean, if anybody was in my camp, they would love that. Because the Affordable Care Act case, easy under that approach, clearly constitutional. On the other hand, Wilson and Morris were probably the strongest advocates of a powerful presidency at the convention as well. So that's actually something that lines up with what conservatives tend to want. They typically have wanted a strong presidency. So that's an example where I think if you're recapturing what the words actually meant, it doesn't line up purely with either a conservative or a liberal agenda, but it's what the words say.
And so focusing on that difference between, or what the words mean versus who wrote the words and their influences on them. One of the conflicts that I've picked up on is this kind of original intent versus original meaning. And although not universally, it seems that conservatives jurists seem to focus on the original meaning of the text, while liberal jurists maybe focus a little bit more on the original intent of the framers or legislatures. I would love to know whether you agree with that characterization, and if so, kind of what are the distinctions between those two approaches for originalism?
I don't think liberals would necessarily say I'm an original intent originalist. It just has too many flaws and has been beaten down a few too many times. I think there is a question of what do you do when the text runs out? And I think that that's maybe where some of the, well, what do we look at in that space, and how do we fill in the gaps is maybe where some of the more of the disagreement comes in. But I think generally, in appreciating Dean Treanor's caveat of, well, do we look at how jurists would have understood these words versus the public, or some combination thereof? But generally, I think everybody starts at the same place of public meaning and this textualist place.
Again, I think that's what we're seeing in terms of a movement over time, right? That original intent is, so it's more manipulable. I think what we tend to have so I would say there are a couple of things. One is, again, I think with respect to the original Constitution, it's really Wilson and Morris, and it's not Madison. But I think most of the people read the Constitution, conservative jurisprudence, read it as if Madison wrote it, which I think is just not right. So, for example, the vesting clause of the Article 2 says President has all executive powers. Right? Vesting clause of Article 1 says Congress has all legislative powers herein granted. Right? So when the very first debate between Madison and Hamilton is actually, he's Morris's best friend. They roomed together at the Constitutional Convention. He should be in Hamilton, except I think, frankly, if he were in Hamilton, Hamilton would be crowded off the stage because Morris is such a big figure. But so the first debate over the power of the president is, can President Washington issue a neutrality proclamation? Hamilton says, of course he can, because the Constitution says the president has all executive powers. And Article 1 says Congress only has powers herein granted. The difference tells you the president gets everything, right? And Madison's like, we don't mean that. That's kind of, it's a little, how much power are you going to give to the herein granted, right? But I think a textualist, would say you read the words closely. Morris might have been an outlier in the convention, but he wrote the language, and so that's the way you read it. So, and that's one area of the difference that I would say. I think the 14th Amendment is another area in which we're seeing a lot of difference, and we're going to see it, I think, in the affirmative action case coming up, because I think Justice Jackson is saying, equal protection means equal protection, and it was understood against a backdrop of, against a race-conscious backdrop, right? And I think the conservative wing of the court, and most people think that it will prevail in the affirmative action cases, say equal protection doesn't have a race-conscious dimension. So that's a case in which essentially it's the text, and I think at least Justice Jackson and the conservative wing of the court are fighting about what the text means. And and I think that there are, I think there are legitimate arguments on both sides. But that's an example of kind of the consequential nature of the understanding of the text, how people can disagree, and how much can ride on it.
One area where there seems to be some ongoing dispute or disagreement is the role of stare decisis and respect for precedent. in originalism. And I know, Dean Treanor, you recently wrote an article discussing this, but Ms. Gervasi, I'd love to hear your thoughts on how stare decisis plays a role in originalism, if at all.
Yeah, I think this might be an area where Dean Treanor and I respectfully, friendly disagree a little bit. That I think that stare decisis does have a role, right? It matters. And when there's a reliance interest, for instance, on precedent, that matters. But if the way we have been understanding the Constitution is objectively wrong, that might be worth reconsidering. I think for me, whether I'm willing to undo decades of precedent or a practice we've been partaking in turns on, are we depriving people of rights, right? So if the way we've been interpreting the Constitution is wrong in a way that does not privilege the rights of the people, that should be reconsidered, and that should be looked at again. Of course, no one would disagree that there are times when we need to undo precedent, regardless of the reliance interest. Certainly there was a great deal of reliance interest on Plessy, right? But that was wrong, that was incorrect, we had to undo that. Nobody would disagree. But for me, whether we undo the law really requires some level of balancing and looking at, well, what is the harm that's happening here, and are we taking rights away from the people? Because at its core, my belief is that the Constitution is a rights-protecting document, and that is why it exists.
Justice Scalia wrote a very famous article in which he described himself as a faint-hearted originalist. And one of the things he meant by that was that sometimes precedent is so deeply established that he wouldn't overturn it, right? So I've written a lot on the original understanding of the Takings Clause, for example. The Takings Clause says, "Nor shall private property be taken for public use without just compensation." And I argue, and I think it's actually now generally, not universally, but generally accepted, that only applied to physical seizures, not government regulation, right? So the government takes your house to put up a federal fort, that's a taking. They pass a regulation that diminishes the value of your property, says we're going to, it's going to be zoned for residential, not commercial uses. That may diminish the value of your property, but it's a regulation, no taking. That's really the original understanding. But then for about 100 years, the Supreme Court has said regulations can also be takings, starting with Pennsylvania coal, famous case. Justice Scalia in Lucas essentially said, we're not going to worry about the original intent. It's been established for a long time that regulations can be takings, and we're not going to disrupt that, right? So even though he doesn't make that in terms of an originalist argument, I think it actually is an originalist argument. And I would say two things. One is, it's very striking, even though there are a significant number of Supreme Court cases in which statutes are struck down before the Civil War, there's only one in which the court overturns one of their prior decisions, and it's very late. So I would say, first of all, there's actually a very strong original understanding about stare decisis, respect for precedent. Now, I think one of the things, though, that has changed over time is, in 1840, you didn't have a lot of, you didn't have as many opinions as you have now. At this point, you have, well over 200 years of opinions. But at the same time, I think the respect for stare decisis reflects a larger principle of original court approach, which is actually kind of a minimalist conception of the judicial role, right? So, and I think this is one where Ms. Gervasi and I may disagree, but if you look at all of the early judicial review cases, they're actually in a very limited category of cases, right? So there, and most of them are involving the Supreme Court's jurisdiction. What can it and other federal courts hear, right? So that's where they're overturning congressional statutes. Now, if you combine the respect for stare decisis and the sense of if you combine respect for stare decisis and this concept of a limited judicial role. What that suggests is that there's some room to overturn cases, but it's limited and evolutionary. So Ms. Gervasi talked about Plessy, right? So in Brown versus Board of Education, first of all, there are two things. One is Brown actually did not overturn Plessy. And the second, it said Plessy doesn't apply in the context of lower school education. Did not overturn Plessy. And the NAACP had actually had kind of a series of cases starting really immediately in the aftermath of the Second World War with the idea that we chip away on the underlying principle of Plessy, and then eventually the Supreme Court will overturn it, right? So what you saw, for example, in Dobbs, is that the majority opinion was like, it was just, we're turning the switch, right? Whereas the Roberts opinion was very much more kind of a limited judicial role. So it was like, it's like, we're not going to overturn Roe in this case. We will uphold the Mississippi statute, but we're not going to overturn Roe. That may be in the future, but that is not today. So I would say, and I'm not, for the purposes of this, I'm not getting into what the original meaning itself was of the 14th Amendment. But the Roberts approach of incremental change with respect to precedent is, I would argue, much more an originalist approach than what we saw in Justice Alito's opinion.
Very interesting. To wrap us up, you're both obviously experts in this subject, in this area, but you are also both educators of the next generation of lawyers, myself included. And so how should students be thinking about originalism as they approach their studies and as they begin their careers?
Why don't you begin first?
Sure. So for me, the most important thing is that students expose themselves to originalism and engage with it and look at the various modalities of originalism and the different approaches and question them. Read the scholarship about them, what feels right, what comports with your sense of the rule of law and what the role of the courts is, and start there. Start by questioning it, but also question when people tell you what originalism is, right? So a lot of people will say that Dobbs and Bruen are originalist opinions. My position is they are not. They are not originalist opinions, and challenge that, right? Push back on that. Well, what does this theory say? And what is actually being applied? And so I think that that's just the most important thing, is exposing yourself to these theories and questioning them and what comports with your sense of the right approach to the law. Reading and educating yourself is the most important thing you can do. And then when you head into practice, be gentle with yourself when you're making a non-originalist argument, because at the end of the day, you're representing a party, and whatever result you need there is going to be the argument you make.
I think that's a very good answer. I would say a couple of things. One is that when you're a law student, you should really, first of all, expose yourself to all of the major approaches to constitutional law. Whether it's originalism or focus on precedent or a focus on living constitutionalism. You should expose yourself to them and then take them seriously and think about what you think. One of the things we have to fight against is just dismissing things we don't agree with. I think with each of these schools of thought, you've got to take them seriously. You've got to think about them. You've got to think about whether it's right or wrong, but you've got to be open-minded to grapple with them. I think with originalism, again, like the other schools of thought, I would urge that everybody, grapple with it, think seriously about it. It's also very important for people, not just as thinkers, but as lawyers, you're very likely to be if you're doing constitutional argumentation, you're very likely to be appearing in front of a judge or a panel of judges or Supreme Court that is largely originalist. So, that's a tool that you want to have at hand. So I think, again, it's part of practice. The other thing is I have to say, I go to many, many alumni events, and what always strikes me is the way in which Georgetown lawyers shape the law in so many areas. So you're partly doing this exercise for yourself, partly doing it to prepare you for a career in the law, and you're also doing it because you may be someone who has a powerful influence on the law in the years ahead. So that's one of kind of our joy as educators, that we're preparing people in all three dimensions. And I would urge people to keep that in mind as they grapple with originalism and every other approach to constitutional law.
Well, thank you both so much. I will absolutely be taking both of your advice. And thank you for a wonderful discussion.
Thank you. You really led us through a fabulous discussion.
Yeah.
So thank you very much.
Thank you, Dean Treanor.